If I resort to the other Ugandan authorities, Your Worship, which my colleagues will also help me with, it is important to trace the common law principle of open justice. The House of Lords, in the case of Scott versus Scott,
Common law principle?
yes, of open justice.
Yes.
In the case of Scott versus Scott in 1913, SC 417. Did hold that publicity is not an inconvenience. Publicity is not an inconvenience imposed upon courts. It is an essential safeguard of the administration of justice. A departure from this principle can only be in recognized exceptional circumstances. And in a subsequent decision of R, Guardian News and Media Limited, R, in brackets, Guardian News and Media Limited, versus City of Westminster Magistrates Court. Imagine in this case, the case was against court itself. 2012. Westminster Magistrates Court. Brackets 2012. EWCA, page 420. The Court of Appeal, the English Court of Appeal, held as follows. Open justice is a principle at the heart of our system. At the heart of our system. Of justice, of our system of justice. And vital to the rule of law. And this, Your Honor, underpins the principle in Sussex Justices, R versus Sussex Justices. R versus Sussex Justices, ex parte McCarthy. Ex parte McCarthy, MC capital CARTHY. 1924, 1 KB, 256, to the effect that justice must not only be done, comma, it, but must manifestly be seen to be done. I will end with two more authorities. One is Indian authority of Swapnil, S-W-A-P N-I-L, Tripathi, that is Tripathi with an H-I, versus the Supreme Court of India. It is a case that dealt with the question of live streaming. Your Honor, it is 20.
Have you given the citation?
Yes, 2018. Close brackets, 10 SCC 639. And the court concluded that open trials and access to the public, open trials and access to the public during hearing of cases before the court is an acceptable proposition. Unacceptable, AN, Your Worship, for clarity.
It's an acceptable proposition.
Is an acceptable proposition. In that case, Your Honor, the court heard that it actually expands access to the courtroom beyond the physical walls, but also educates the public. On the functioning of the judiciary. The South African court, Your Worship, has also gone miles in allowing live streaming as a means of access to information, of course. That is the Constitutional Court of South Africa. In the case of
As a means of access?
Accessing information in court proceedings. Through live broadcasting. I refer to the case of SABC, South African Broadcasting Corporation, versus the National Director of Public Prosecutions.
You beg your pardon? And the parties?
The parties SABC, South African Broadcasting Corporation Limited, versus the National Director of Public Prosecutions. That is 2006, close brackets, ZACC 15. that broadcasting enables members of the public to witness proceedings. To witness proceedings which they could not physically attend. Further than physical public presence does not necessarily inhibit judges, counsel, and witnesses. The mere fact that members of the public are watching remotely does not automatically establish such inhibition.
Does not automatically establish such inhibition. And that it is less intrusive, and therefore justifying. As I conclude the worship, before I hand over to my colleagues to introduce the other authorities, permit me to say, one, that the state has miserably failed to justify the case of locking out citizens from the proceedings of this court. That evidence could have been brought by way of affidavit with real-time data. Short of which it is only conjecture. Actually, the state must also style up, and I mean the government of Uganda. Mind your language.
I am minding it. And I'm going to justify it.
It should have been brought by affidavit.
By affidavit, with the real-time data attached to that affidavit. The language I am using, Your Honor, is basic English of the state styling out. How? Bringing to court cases that are justified. I conceive this application as one that is intended to shield the government or the state in terms of its inadequacies. It should not be open to the state. And you should not referring to the representatives here. These are lawyers representing the state. It is not, should not be open to the state to bring embarrassing cases and then say,
objection, Your Worship. Council needs to address court with decorum and avoid insinuating unverified information.
Your Worship, how would she know it is verified before I speak out? I'm going to speak
You're
out.
referring to the cases as embarrassing.
Yes.
How verified
I'm
is that?
going to demonstrate. We just need to be patient. Your Worship, if the case is not embarrassing, the state,
Objection upheld.
Mr. Blair.
before I conclude,
Upheld.
okay, I'm right.
Okay, proceed.
Your Worship, if the accused person committed offenses against the public, and the state has done its thorough job in investigations and prosecuting, why would they not want the public to see as they expose the criminal in the dock that this is a man who propels public disorder, responsible for your lack of sleep, is here. The police has consistently been paraded before the public, people they have arrested. And they say the person